Must a judge always grant guardianship of an elderly person who is the subject of a guardianship petition? While most judges place people diagnosed with dementia or Alzheimer's into a category of refusing care, saying they don't need help, refusing to move to a care community, or even denying that they have memory loss, any person who meets one or more of these descriptions and who is deemed to lack capacity by way of a medical evaluation ordered by the court are more frequently placed under court-appointed guardianship, with a family member or a professional being that guardian. But what if a petition submitted for guardianship of an elderly person shows that the elderly person has participated in medical care? They've always been proactive about their health. They're not even denying that they have memory loss. What if this case, this elderly person, is the 1 in 1,000 cases, 1 in 1,000 people that comes before the court, and nobody mentions this to the judge? Or the judge ignores this important fact because it's easier just to stamp that piece of paper, grant a guardian, and be on to the next case. Or what if a court-appointed attorney for this potential ward falls into the same pattern? Person has dementia. They're crazy. They don't know what they're saying. They don't know what they want. They've lost their mind. It's so much easier for me as that attorney just to go with the flow and not fight for them and let the judge grant guardianship and be on to the next case. Do you ever wonder how many older adults every year are placed under guardianship against their wishes or the wishes of family members who don't understand the guardianship process and who don't have the money to contest the petition? How many older adults with dementia or Alzheimer's are harmed by a court system that is supposed to protect them, but because nobody cares enough to take a closer look at each individual situation, all of the details, all of these cases get approved? So the question I'm here asking today is, do all guardianship petitions necessitate guardianship? Based on my experience with situations that might have appeared routine on the surface but were not, I say no. I'm Pamela D Wilson. I'm a guardianship expert witness with 25 years of experience as a professional fiduciary, guardian, conservator, medical power of attorney, financial power of attorney, personal rep of the estate. I was also a care agency owner. You can learn more about me by visiting my website, PamelaDWilson.com, or clicking below and you'll find a link to my website. In my opinion, in all situations, a judge should question the motive behind a guardianship petition. Does the person petitioning for guardianship have an ulterior motive? Are there unknowns like control or maybe money? Is this person angry at another family member for any reason? The judge should really give thought to those questions and this question: are there really no other least restriction options to granting guardianship? As a court-appointed guardian and medical power of attorney for over 100 people, it's my professional opinion as an expert who writes reports and testifies in court to say that guardianship is not always necessary. There are other least restrictive alternatives, as long as there's evidence to confirm that a vulnerable person is participating in medical care. They're agreeing to medical care with the support of a medical power of attorney, in fact, who, if guardianship was absolutely necessary, would be that nominee. So, in my professional opinion, if there is no clear and convincing evidence to support that an older person with any type of cognitive impairment needs a guardian, then the least restrictive alternatives should take priority even over a medical evaluation. So, if you're an attorney or a law firm, you're representing an individual in a contested guardianship case or representing a family, even if you have a medical evaluation, even if it exists to say, yes, this person lacks capacity, they need a guardian, but the person is participating in care. Your client, this person, may not really need a guardian if there's a power of attorney agent. And especially if guardian statutes in your state focus on least restrictive alternatives. There are some states out there that do this. So in these states, and really in all states, the judges, the court system, should consider whether a guardianship is the only option when presented with enough evidence or testimony to prove otherwise. So if your law firm, if you're a family member, you're looking for an expert witness who can give an opinion in a contested guardianship case, who has the credentials and the experience to help you, my contact information is below this video. You can also visit my website, PamelaDWilson.com. My name is Pamela D. Wilson. I'm an expert, an advocate, and a guardian expert witness for people who need help in these and other types of situations.